So hi everybody, I'm Elaine from Cerebra, and today I'm joined by Kelly Knight from Hyphen Law, and we're going to be having a chat about planning your child's future and that whole process of transitioning from child to adult. So hello and welcome, Kelly. Thank you so much for joining me.
Good morning, Elaine. Thank you so much for having me too. It's been really nice to be with you today.
Yeah, and I know this topic is a huge concern for lots of parents, isn't it? Because Kelly has written an article for us about this topic, which you'll be able to read in detail on our website. But as you rightly point out, childhood years go in a blink, don't they? And before you know it, you know, they're young people and ready to, you know, go into the world independently. So before we get started on all of that, Kelly, I just wondered if you could tell us a bit about yourself and what you do at Hyphen Law.
Yeah, of course. So I work at Hyphen Law. Hyphen Law is a specialist law firm that advises clients in relation to the Court of Protection, Mental Capacity Act, and specifically in relation to Property and Affairs Deputyship. And we also advise in relation to personal injury trusts. So the majority of our clients have had or have a brain injury. Some of our clients have had a catastrophic injury as a result of, for example, a road traffic accident or an accident at work. Some of our clients have had a birth injury, such as cerebral palsy. And some of our clients have mental illness, dementia, and also some of our clients don't have a brain injury but have physical disabilities, and that's why they require a personal injury trust. So our clients range from the very small. I think our youngest client is 6, and we have some clients that are in their retirement age. They come from all different backgrounds. They've had their brain injuries or physical disabilities at different stages in their lives. They come with, some have families, some have parents, some have care teams. So we, work with a whole variety of people. And what we do is we advise deputies or trustees. We can act as a professional trustee, we can act as a professional deputy, but we also advise those people who act in a lay deputy, so or a lay trustee, so those that act for their mother, father, children, and offer them some help and some guidance. And we can offer help and guidance not just in relation to deputyships, but all those things that go with deputyships. So we advise in relation to managing affairs, the public guardian's office and what's expected that side, statutory funding. We help guide in relation to educational healthcare, setting up care teams, adapting houses, all those sorts of things. So we're quite busy, and we like to provide a bespoke service to our clients, because every client has their own individual life that requires individual different things. So we're quite bespoke. In terms of what I do, I'm an associate legal director within the team, and I support Christine Bunting, who's the director of Hyphen, and we have a whole support team of qualified staff and paralegals and secretaries that help keep Hyphen running as well as we do.
Oh, thank you for that. So as you just mentioned, and I mentioned earlier, this is a big stage in a young person's life, isn't it? Transitioning from childhood to adulthood. And I've read your article, and there are so many different aspects involved in making that transition. And you mentioned just now about the Mental Capacity Act. I just wondered if you could tell us a bit more about what that is, and who does it apply to, what's it there for, and how it fits into this whole transitioning process.
Of course. So the Mental Capacity Act is a big act. It came in, it's Mental Capacity Act 2005, but it didn't come into force until 2007. And it is the legal framework that's now in place in relation to those that lack capacity to make decisions, and help give a legal framework about how those decisions should be made on that person's behalf. So it applies to all of those age over 16. I know we all think as an adult as 18, and in many reasons and many areas it is, but under the Mental Capacity Act, it actually applies to 16 and 17-year-olds as well. And although they're not called adults, they are recognised as young people, and they should be able to make decisions in certain areas where they're able to do that themselves. So it's often really difficult to when everyone talks about, you know, being an adult and parental responsibility, everyone sees 18 as that sort of that magic age, and many times we would like, you know, to make decisions for our children up to 18, because they can make all sorts of decisions at 16 or 17 that we may not completely agree with, but they are entitled to make those decisions even if they are unwise, where they have the capacity to do so.
Okay, so speaking about sort of decision making, who can make decisions for children and young people and adults? What are the differences?
Sure. So if someone has been assessed as not having the capacity, so the Mental Capacity Act sets out how someone's capacity should be assessed. There are different elements. So someone needs to understand, retain, weigh up and communicate in order to have capacity to make a decision. If they can't do those things, then we'll need to look at someone making a decision on that person's behalf. Just because someone can't make a decision doesn't mean that they might not have wishes and feelings that should be taken into account. So even if someone technically doesn't have capacity, they may be fully able to express a wish or a feeling about certain things. So that will always need to be taken into account when a decision is being made on behalf of that person. In terms of who can make a decision, this is a difficult area, because there isn't one specific person that I can specify that can make a decision on behalf of someone else. Quite often it's a group of people. So for example, if we're looking at a young person, it might be the parent or carer, or the person that has parental responsibility for that 16 or 17-year-old, but it also might need to be made in conjunction with a teacher or a social worker or a doctor. So it's what we call a best interests decision, and there is a best interest process that needs to be followed, and that's all set out in the Mental Capacity Act. But basically, in terms of the Mental Capacity Act and the best interest process when a decision is being made, it will depend on the type of decision and who should be involved. So we could have a really simple decision that needs to be made. So for example, if a young person needs to consent to have a blood test, for example, the GP will establish whether that young person has capacity. If the young person doesn't, then the realistic probably first option is for that GP or nurse to ask the parent, or to ask the young person's parent or the person with parental responsibility. That, you know, is quite a straightforward decision to be made. But if, for example, that young person needs a decision around, you know, a significant operation, or where they should live, for example, it might have wider people to be involved. So there might be other doctors to be involved, there might be other family members, there might be social workers, there might be carers, there could be a whole, you know, a whole number of people that need to contribute to that decision-making process. So it is case by case. This capacity is time and decision specific. So just because you can't make a decision about something doesn't mean you can't make a decision about everything. So for example, a young person might be able to consent to a blood test because they can understand what a blood test means, but they might not be able to consent to I don't know, like an organ donation, because they don't understand the implications of that, for example. So there are, organ donation is a bit different, because it's not quite a straightforward procedure, and there are implications to that, but just those kind of things just show the difference in capacity that would be required. So I just want to make sure, you know, just because one person can't do one thing doesn't mean they can't make a decision in relation to something else. And that's really important, that every time a decision is being made, the person's capacity is assessed time and time again, because it can change from day to day, and it can change from decision to decision that needs to be made.
Okay. And I read in your article, Kelly, about deputyships.
Yeah.
So could you tell us a bit more about what a deputyship is and how they work, and and you know, the sort of how it might work for an individual child, really.
Of course. So a deputy is someone that is appointed by the Court of Protection to make decisions on behalf of someone else. So there are two types of deputyships. There's a property and financial affairs, and there's a health and welfare deputyship. So when it comes to adults, it's relatively straightforward, should I say. So if someone doesn't have a power of attorney, but doesn't have the capacity to manage their affairs, an application can be made to the Court of Protection for a deputyship to be appointed. So that can be, as I said, for property and finances and for health and welfare. Health and welfare deputyships are not as common as property and financial affairs deputyships. Property and financial affairs deputyships, there are much more, and that is because potentially a health and welfare deputy can make really significant decisions that have a massive impact on someone. They could make, medical decisions, decisions about where someone lives, and it might not be always right to give one person the authority to make those single decisions on their own, and the best interest process may be the right thing to do, and that's the same for children. So where a child is not going to have capacity at the age of 18, the court can appoint a deputy. If the child is likely to have capacity, or is a chance the child's going to have capacity when they're 18, then the court either has two options. They can either not appoint a deputy and say things should be done under the best interest decision and parental responsibility, all those sorts of things, and where there's any disputes, you could go to the court for a one-off decision to be made, or if the court thinks that there's a chance the child might not regain capacity, but the evidence, the court isn't sure, the court could appoint a time-limited deputy, so appoint a deputy up until the child is 18, and then the capacity and deputyship has to be reviewed again at 18. So there are those two options. A deputy is a named person on a court order, and the court order will set out what that deputy can and can't make decisions in relation to. Okay. And that's one of the reasons why property and financial affairs deputies are more common. You know, you can write an order saying someone can buy a house on someone's behalf, or someone can manage a bank account on someone's behalf, or someone can take investment advice on someone's behalf. But to put in an order saying someone can make, welfare decisions on someone's behalf, whether someone should have treatment or not, that's quite wide ranging, and could, there's lots of things that the court might not envisage or want someone just to have that outright authority to make those decisions. So that's why the court is hesitant in just giving one person that authority to make those decisions. That doesn't mean that the court doesn't, and in some circumstances the court will make a health and welfare deputyship. The court would prefer to see that the best interests process has gone through, and if a decision cannot be reached but everyone is in agreement, then an application can be made to the court for the court to hear all the evidence and then make a determination as to what would be in that young person's best interests. And that's quite often the kind of cases you see in the news, where a single issue has gone to the court. So if there's life-sustaining treatment, or there's whether someone should live in a certain place, or have a deprivation of their liberty, it's specific questions that are put to the court rather than a general authority for someone to manage someone's affairs.
So I can tell from just touching on things this morning that there are a lot of things for parents and carers to think about, aren't there, when their child approaches that age. And with your experience, what sort of practical things would you suggest that parents should be starting to consider? And how quickly as well, isn't it? Because we've already said how quickly the years go by. Is there an age where you should really start planning for your child's transition?
I think as parents, we never stop, do we? We never stop and we never start. It's always in the back of our minds. And I think that just having it in your mind that at some point we're going to have to start planning. I don't think you can ever start planning too early.
Okay.
I think the teenage years are, the 13, 14-year time is a time to really start thinking about things. There will be a whole array of areas, and it will feel like a complete, minefield. It's a pretty scary time being a parent, let alone when you are going to have to potentially make some decisions or get the right people involved. So there will be things, for example, like care funding. Some children may be under child services in terms of funding, so they may get health funding for certain things, and actually the transition for funding into adult care funding, so continuing healthcare funding or local authority funding, that should start to be planned when the child's 16. So when that transition happens and the child becomes an adult and transfers over to adult statutory services, the plan is in place. That there's no drop in funding. It's all a smooth transition, because the child who then becomes a young adult, who then becomes an adult, so a young person then to an adult, they will have different needs. They may want to do different things. You may go from school to college, to into the community. They may be at home when they're a child. They may be in a placement, and those placements will change when they become an adult. So they will need to be thought about, where they're going to go, how they're funded. So they're all really important things, and really, really stressful things for parents to be thinking about. The children and the young person can be doing really well in one placement or at home, but to know what's going to happen to them when they become 18 and that placement ends or that funding ends is really quite stressful. There are things to think about as well. So, for example, what state benefits that young person might be entitled to. So they will change. Potentially different benefits will open up at 16, but the big change will be at 18, or when that child or young person comes out of education. So that will need to be thought about. And there'll be means tested benefits. So, for example, employment support allowance or universal credit that they might be able to claim, and there'll be non-means tested. So, for example, personal independence payments. There may be implications for things like council tax as well, which will be important to consider and get the right advice around that. Also important to think about a will for your child. At 18, they can technically make a will. Or if they don't have capacity to make a will, then the Court of Protection can make one on their behalf. It's called a statutory will. So it would be important to think about things like that. And again, a statutory will is something that you can plan before that young person turns 18. So we would start looking at that for a client at the age of 16, and start talking to the family and talking to those that might be set or would inherit, because there's a set of intestacy rules that apply if someone doesn't have a will, and we need to make sure that their right for the client with a will should be made. We have families now that aren't the traditional families. Our families are made up of all different people now, and it's important that where parents have remarried, or they've got half siblings, those things might not be taken into account under the intestacy provisions, but understandably that person might want those people to be included in any division of their estate. So those things are really important to think about as well. And it's also important to, as a parent, to think about what you have done to set up your affairs. So as a parent, have you done your will? Have you done everything you can to set up your affairs? Is that all provided for adequate? Is your child provided for as you would want them to? There are trusts and things that can be set up if you have an estate to pass to your child that might assist them with funding and things in the future, and also powers of attorney for parents. Parents, if they become unwell, might need someone else to make decisions on their behalf, so it's worth parents thinking about powers of attorney and wills for themselves as well. And they're just a few of the things that we would advise people to start thinking about. There's education things and educational healthcare plans and education settings and all those sorts of things that go with that as well. Whether property needs to be purchased, care teams need to be set up. It's a really, really big thing. And then that's where we say, start planning early, because if we can do these things, or at least plan for these things one thing at a time, it doesn't feel as difficult or as overwhelming. But if we get to 18 on one day and those things aren't in place, everyone can feel quite panicked, understandably. It's all resolvable, and we can, there's always a way to help, but just planning is key for these things.
Yeah, some time to think, isn't it, and really consider what's best, rather than having to make decisions quickly, I guess.
Yeah, and we always feel pressured if we have to make decisions quickly. But if we can do things in a considered, calm and collective way, and we have all the information in front of us, then we can make an informed decision that we feel is right for our child or young person. And we can feel confident in those decisions. And when we make things panic, sometimes it makes us feel uneasy, or we worry that we haven't made the best decision, or considered everything, even if we have. So it's just about planning.
Fantastic. So I know we have just basically skimmed the surface of some topics this morning, that Kelly has written quite a detailed article with lots more information and guidance, and that is on the Cerebral website, and there should be a link alongside this video if you'd like to go through and have a read. So I'd just like to say thank you, Kelly, for joining me this morning. It's been great to talk to you, and to just find out a bit about some of these things, some of the I don't want to use the word challenges, but some of these decisions that parents and parents have to make, and to be reassured that there are all of these things out there that can help and support them and their child as they grow. So that's been really useful. Thank you very much for your time today.
Thank you very much indeed.